Thank you, everybody, and welcome back. We now have the question and answer panel for the first part of our presentations today on appointment delays. I want to reintroduce you to Professor Ann Joseph O'Connell, Dr. Bill Galston, Professor Nina Mendelsohn, Professor David Lewis, and Professor John de Figueiredo, who is the Edward and Ellen Marie Schwartzman Professor of Law and Professor of Strategy and Economics here at Duke, who has graciously volunteered to moderate this panel for us. So welcome again to everyone, and let's get started.
Great. Thank you very much. I thought this was an excellent panel. I want to thank the Duke Law Journal and Bill in particular for organizing this. I thought I would start off with a question, and then I would see what we have to say about that, and then open it up to the audience. We talk a lot about the disadvantages to the lack of appointments and the vacancies that occur. But we look at it mainly on its effect on the administrative state. But it seems to me one of the advantages to having Congress control some of the vacancies, control the appointment process, is that we gain overview or congressional intervention in the administrative state. One of the big critiques is that the president has too much control in the administrative state, and this is just one tool that we have in which Congress can assist in helping to check the power of the president. In addition, vacancies and blue slips and these kinds of things, confirmation processes, it would seem, also gives Congress a tool in which to log roll other policies across Congress. And so while we see a lot of disadvantage in the administrative state, we may be actually seeing an advantage to democracy. And I was interested, particularly from Professor Mendelsohn and the other panelists, what they think about the importance of mitigating congressional control of the appointment process versus the benefits to the overall democracy. Maybe I can start with Professor Mendelsohn.
Okay, then. Hi. So this is a really interesting question, right? What are the effects on Congress, and is there anything good to say about that, right? And as you and I talked about during the break briefly, this is something I had initially considered addressing in my paper and then decided not to. Clearly, I think you're clearly correct that Congress gets something because of confirmation delays, and they clearly get an increase in leverage. Right, they clearly get a strategic advantage because what it does is as you say, it gives them something to log roll over, increasing things that they can negotiate with the administration over. So to that extent, it represents a shift in power to the extent they take advantage of confirmation opportunities to create delays and then use the prospect for reducing those delays as leverage to get other things that they want, whether it's particular appointees or something else. So the question is that in any way something that we can see as a positive development? And I guess I'm a little bit more circumspect on that. One positive development we could see is that confirmation delays give Congress an opportunity to deliberate longer, gather more information, and make better decisions over whether to confirm a particular appointee. I have to say, I think this seems unlikely. The increase in, let's just take as a given that Congress collects lots of data for every appointee. We've been hearing about that already this morning, perhaps too much data, and perhaps they spend 3 weeks to a month processing that information and having hearings. What good does it do to add an extra 5 to 8 months or longer for a particular appointee? Does Congress gain anything in terms of information gathering or information processing or deliberation? I guess I have not looked at this in detail, but I would suspect not much. I would suspect not a lot of deliberation gains on a particular appointee. What about other gains? It certainly increases Congress's leverage. Is that a good thing? I think that's a very complicated question. It depends, I think, if you think the president somehow has too much power, Congress doesn't have enough, perhaps Congress is could be argued to be a better representative of personal preferences than the public's preferences and somehow the president. I think the evidence is I think there's lots of arguments you could make both ways about that. I'm not at all sure. We got lots of safe seats in Congress, so maybe Congress isn't so good. Professor Jerry Mashaw years ago made what is still, I think, a very compelling argument that a lot of our national debate about what kind of government we have takes place in the presidential election at least as effectively as in congressional elections. If that's true, maybe we don't want an increase in leverage being given to Congress through the power or the power that they are increasingly trying to command by delaying confirmations. Okay, but I'd be interested in other people's views on this.
So just a few disjointed thoughts on Congress. So the first is Congress wants to increase the number of Senate-confirmed positions. So the Food and Drug Administration, which was mentioned this morning, the head of the FDA in the Carter administration was not a Senate-confirmed position and was made one, and there are current proposals in Congress to add Senate confirmation to sort of regional positions with regard to the Fed, for example. So on that, I think that Congress wants it, and they try to get it, despite this 2011 Streamlining Act. The second comment, unrelated to the first, is I do think the idea of log rolling appointees is a really interesting one, and Dan Ho at Stanford has some work in particular about independent regulatory commissions. So it used to be that we put up, or presidents put up nominees to these independent regulatory commissions one at a time, and now the current process is a batching one. So you put up a slate of nominees to the National Labor Relations Board, for example, and that might help. The last comment I'll make, unrelated to the first two, is to think, though, about a cost. When we have high vacancies, in part what happens is there are these acting officials, yes, but there's also the rise of White House advisors and czars, and the Congressional Research Service and others have found that those officials testified less in front of congressional hearings. Part of that is about the White House in certain areas claiming that White House officials don't have to testify in front of Congress, and so you actually might end up with less accountability overall.
Thank you. Yes.
I think the political circumstances within which these formal institutional questions are posed makes a very big difference. In circumstances of intense political polarization, arguments about nominees are a kind of proxy war for arguments over public policy. And so from a constitutional standpoint, it seems to me the question, especially at the beginning of an administration, is whether the President of the United States is entitled to have a team around him or her that enables the President to formulate his or her policy preferences clearly, effectively, and in a timely manner so that they can be brought before the Congress of the United States. And if you, that's number one. Number two, the senior officials, the officials below the cabinet secretary rank in executive departments, serve as an important source of policy advice for the president. If they're not there, the career people are not going to be trusted to perform that function to the same extent, however much they may be trusted to carry out administrative or more purely ministerial functions. And so I absolutely agree with Ann. The inevitable consequence of weakening the departments as sources of policy advice is that more and more of that function will be taken into the White House staff. And that diminishes the power diminishes the power of Congress, including, as Ann said, the power of Congress to compel testimony. Presidents of both political parties have pretty zealously safeguarded that line. And in most circumstances, they refuse to allow members of the White House staff to testify, and they've, by and large, gotten away with it. So the idea that this is a gain for accountability, strikes me as contrary to clearly observed fact.
I would just add something quickly here, which is that it'd be interesting to know as an empirical matter whether agencies with persistent vacancies report that they're more responsive to Congress than to the White House. And I think that if we at least compare independent regulatory commissions to executive departments, it's certainly true that they report that they're more responsive to Congress than the administration. And so I take your question, John, to be, could this be a strategy on the part of Congress or congressional committees to say, basically, we have the influence we want. The way we influence agencies is not through the people we confirm or not confirm. We influence them through our decisions about what we say when they come before us and ask for appropriations or they ask for reauthorization. And so for us, the delay may not cost us that much. And I think that's a really interesting question.
Let me open it up to the audience. Yes.
This question is for you. Years ago, in the Clinton administration, the federal government hired me to do a study of their adjudicative processes. The thing that struck me during that process was the number of vacant positions. But the vacancies were not attributable to Senate delays. They were more attributable to Clinton's failure to make nominations. So when I talk about vacancies on the one hand and delays, I don't necessarily, those seem to me to be two separate questions. And I always remember on one agency where I was, they didn't have the head of the adjudicative branch there. So I asked them the question, what are you doing? I mean, are you deciding cases? And they said, oh, no. We're not deciding any cases now. And I said, so what are you doing? And they said, well, look over there. And they showed me this table that was just filled with cases waiting for somebody to be appointed. But like I say, it was a presidential failure, not a senatorial failure.
Yes, so that's true. And other work that I've done in this piece that others have mentioned called Vacant Offices, where I looked at vacancies from the start of the Carter administration through the end of George W. Bush's administration. You can think about a job being open having 3 periods to it. So the preceding official leaves, and there's the time from their departure to the time that there's a nomination. Call that the nomination lag. And then there's a period from the nomination being received in the Senate till it being confirmed. Call that the confirmation lag. There's actually a 3rd period, though as we increase the number of people coming from Washington, D.C., for them the period's really small. But if you have to move from California, there's a period from when you get confirmed to when you actually start. Call that, I don't know, the starting up lag or something like that. And so in this other empirical research that I've done, the nomination lag far exceeds the confirmation lag. So as a magnitude, the nomination lag is often at least twice as long as the confirmation. And I'm careful in my draft to say, I'm kind of setting all these other things being equal, but the nomination lag is huge, and I don't want to undercut that. And I was quite harsh on President Obama's administration at the start because a lot of the problem in agencies and in the courts was actually his failure to nominate. Now, of course, that nomination takes place in the shadow of confirmation. So if you think you're going to have a hard time in the Senate, some of what delays you is, in fact, the problems in confirmation. And if I could just add a quick other point about adjudicative functions or agencies, I just want to flag that we don't get temporary officials, acting officials, in at some of the agencies that do most adjudication. So the National Labor Relations Board, you're not allowed to put acting officials in there. So in terms of Nina's work, you have to think, well, those acting officials, these careerists, may kind of compensate in executive agencies, but are not helping out in independent regulatory commissions.
But then we have to ask why the nomination lag has become so extraordinary. And and I may be Johnny One Note on this, but in my experience, anecdotal though it is, the degree of financial disclosure is a major contributor to nomination lag. The amount of not only if you have the information at your disposal, it takes a lot of time to fill out the forms, but in 95% of the cases, the degree of detail of the information that's requested and the amount of time it covers requires requires individuals and indeed entire families to set aside substantial portions of time over a period of months to accumulate the data on the basis of which this disclosure can occur. And, I stand subject to correction, but everything I know about financial disclosure tells me that in the past 3 decades it has become more and more and more burdensome. And this reflects a mentality in Washington and in the country that I think is a symptom of dysfunction.
Our surveys of appointees in the early 2000s showed that it wasn't just time, it was also money. Because of grand cases involving the failure to appropriately declare one's payments to other parties, for example, everything tightened up, and appointees, nominees started paying advisors to double and triple and quadruple check their applications. The other issue, of course, that Ann knows well is the increasing length of the White House reporting forms. We did have reform in the 2004 Director of National Intelligence legislation that came out of the House. It was a massive package of reform that we thought could sneak through. The great investigator Carl Levin decided that it was not such a good thing because it didn't cover congressional and judicial nominees, therefore it should be stopped. And what business was it of the House to seek to regulate appointments? So, at any rate, that's just a note to the whole thing.
Yes, let me go to the far back there. Neil?
Great discussion. Thank you. So one of the problems with process discussions, whether in admin law or federal courts or con law, is that the substance matters a whole lot, and it often goes untalked about. So this is not maybe a helpful question or an intellectually interesting question, but I think it bears on the facts of the matter, how we think about these issues. I'm trying to imagine this gathering taking place in year 7 of the Cruz administration. And I'm wondering how concerned I ought to be about appointment delays in instances in which I think the appointees, if confirmed, are going to do great harm to the Republic. So I can't imagine I'm going to be terribly concerned with judicial appointments, which is what I know best. The agencies I know less about. If you're telling me it's actually going to redound to the benefit of the White House and result in more political control in the White House and less in the Democratic Congress that's trying to oppose President Cruz, maybe I'll have some concerns. But I mean, to what extent are what you folks are talking about really trans-substantive and procedural all the way down, such that one's views about what the president wants to accomplish and what the nominees are going to do once confirmed really ought not to affect our analysis of how much of a problem actually exists?
Well, I'm going to give you an answer that may surprise you, and given the tenor of your question, probably will not please you. And that is, presidential elections are supposed to settle some things. And one of the things they're supposed to settle is the general orientation of nominees for senior positions in the executive branch. If a presidential election is simply an invitation to continue the struggle during the transition and during the early months of the presidency, then I think that is a substantial impediment to the actual functioning of our constitutional system. The president is entitled to put his own team or her team around him or her, especially at the beginning. That is a trans-substantive proposition about what presidential elections are supposed to settle and what they're supposed to leave open. The correct venue for policy debates is policy debates. And the system becomes profoundly distorted when personnel arguments become proxies for policy arguments. And I feel quite strongly about that. And I say this as someone who voted for President Obama twice. The fact that he had such a hard time staffing his administration, I think was a disservice to regular constitutional order, if I can use that phrase. And I would say the same thing about President Cruz. If he wins the election, he deserves to be able to make senior appointments on the basis of competence and the orientation of those nominees, which will reflect his orientation, is not a reason to reject them.
I think Neil, the difference in the nominations that we're talking about matters. So I agree with Bill, and I think Bill would limit his position to executive agencies. I'm not sure what Bill's position would be on independent regulatory commissions, which have terms longer typically than the term to which the president has been elected with removal restrictions. And then, of course, probably your particular interest, the courts, with lifetime appointments and would be the extreme. But let me just say a story. When I presented the original work on vacant offices to the University of Chicago Law School, it was an early draft, and I just talked about all the various costs of vacancies. And I must have gotten 20 questions, which all had the theme of, why are you so worried? This is fantastic that they're 25% of the time there's no one there. And it wasn't a political perspective. It was sort of their view of social welfare and an economics perspective. And the idea being that if there were fewer people there, and we just don't know empirically, as Nina suggests, that there would be less regulation. And so it didn't matter whether it was sort of Republican or Democrat, but with less regulation, that was going to be better, economically. And so I did include more in my paper about, particular advantages of vacancies, but I still believe on net it's a cost.
Just what presidential elections settle. You also have to say something about what congressional elections settle.
Yeah.
Yep. Yes, in the front here. You had a question.
So Neil just stole a lot of my thunder, but I think, right, to say that presidential elections matter, you do also have to say that congressional elections matter, and one thing that they do is qualify the result of the preceding presidential election, right? So you might be able to say that from 2008 to 2010, to the extent that we think it's sensible to talk in terms of mandates or in terms of public support, that Obama had a lot of it, and then in 2010 there was sort of a new sort of public judgment that he lost a lot of it. So it seems to me, and this goes back to sort of what John led off with, that there's a lot of room here for log rolling. There's a lot of room to mix personnel and policy. And in fact, to say that you have to keep them separate is to simply remove a lot of the levers of congressional power. Right? That you hear this a lot in public discourse, right? Unrelated appropriations shouldn't be held up as a means of influencing, policy that's not directly related to it. Appointments shouldn't be held up as a means. Well, at some point, then there's pretty much nothing that Congress can use as a lever of power. And in a sort of modern administrative state where the executive has all of these different levers of power that it's constantly able to tug on, that results in a sort of continually weakening Congress. The response, part of the response we've gotten so far as well, actually there's sort of a hydraulics to it, right? It'll just switch into the White House and into czars. But of course, Congress has means of dealing with that too, right? For a long time, the head of OMB didn't require Senate confirmation. Then after the Nixon administration, that was changed. For the first decade, the head of OIRA didn't have to be Senate confirmed. Then in the Reagan administration, Congress passed laws changing that. In the last few years in the appropriations packages, Congress has included riders preventing the creation of lots of new kinds of czars and things like that, right? So there are ways that Congress can use sort of other mechanisms, right? What I took John's opening comments to suggest is that we pull back the lens and not think about appointments just in terms of the appointment of one person to one position, but think about it in a more systematic sense and think about how it influences other parts of the administration. How, for example, the Brennan hearings allowed a sort of bipartisan coalition led by Rand Paul, but with Wyden and Udall as well, to raise important points about the national surveillance state. The way that the Lynch hearing is allowing Republican critics to raise questions about unilateral action on immigration. And if you take that lever away, what's the context for raising that, given that we have both a presidential veto and a very powerful administrative state?
I take it that was directed to me. I am entirely sympathetic to the idea that that nomination hearings, confirmation processes should be used to vet very important policy questions. That's fine, and I never argued against that. But two things. First of all, yes, Ann, you're absolutely right. I'm talking about classic executive branch departments. I'm not talking about independent regulatory agencies and a fortiori. I'm not talking about the courts. But the idea that the Congress of the United States has no effective way of expressing disapproval of and even blocking executive branch actions other than the confirmation process is, I think, simply wrong. It has many other ways of doing that, and the problem that I have with using the nomination and confirmation process to do that is that it is the worst way of doing that. It's the way that does the most collateral damage. If you don't like if you don't like the president's policy on immigration, well, the power of the purse is available. Lawsuits are available. There are all sorts of ways of doing this that put the controversy where it belongs in a way that doesn't further damage the functioning of the executive branch. And the idea that the president is all powerful and that Congress is Lilliputian and needs to grab for all the. I mean, maybe I'm just representing the view from the executive branch, but the view from the executive branch is exactly the reverse. And in part, this is a discussion about the minimum conditions of executive effectiveness, particularly in conditions of intense political polarization, where the effort is not to get the president to compromise. The effort, very consciously declared, is to stop the president. Compromise is not the point. Log rolling is not the point. The point is to stop as much of what the president wants to do as possible. And Congress has ample powers of stopping the president from doing what he wants to do. And if you don't believe me, just look at the political history of the past 4 years. So I am unpersuaded that the confirmation process is the right way of getting the president to change his policies.
Yeah, Professor Mendelsohn.
Yeah, so I think that's an excellent set of points. I just want to add one piece to that. Let's just say, for the purposes of argument, that a vacancy would actually stop work at the agency, and it sounds like at the National Labor Relations Board and independent independent commissions and so forth, it really does have that potential. Just think about it from the standpoint of congressional process. To get a policy change through substantive legislation requires a majority of the House and the Senate to pass it, right? And you have to get the legislation through the committees. That's a certain amount of deliberation. There's a veto gate there. You have to get legislation through the House and the Senate. That's subject to a presidential veto. To get work stoppage through a confirmation does not require that level of majoritarian deliberation. A minority can change policy, and we might think of that as not a desirable way to effectuate a shift on policy goals. So I would suggest normatively, it's a less valuable sort of congressional deliberation to the extent that's the mechanism for accomplishing a policy change.
Great, thank you. Yes, in the back there.
I had a question about Table 9. I have to say I found it rather depressing. So there are mild diminutions in the delay for judges. I read this as -15 for district and -5 for courts of appeals, but huge increases in the delays for executive officers, +53.
Well, could you just tell us what the title of the table is?
Failure rates, percent, and confirmation length, days by type of organization, and empirical data. So +53, +43, +80. Almost doubling, +25. So using the nuclear option metaphor, maybe to an absurd length, I'm reminded of mad, mutually assured destruction, and perhaps of the 80s movie War Games, in which the computer Joshua takes us to a point of no return with Matthew Broderick. And it seems to me, this is very troubling, because the nuclear option, based on your data, appears to have precipitated a nuclear response by the Senate Republicans. And I'm just wondering, from sort of a Rawlsian veil of ignorance original position, if both parties think they're going to win elections every now and then, why not confirm, at least for cabinet-level department officers and sub-cabinet officers within the presidentially controlled agencies, why not confirm them on the theory that, well, they won this one, but we'll get them next time? And it just seems to me, if you know that you're going to win some and lose some, and as Bill said, elections are supposed to have consequences. It seems to me there's a good case to be made based on these delays that the nuclear option has failed with respect to the vacancies that are most central to the functioning of the executive branch and to animating a plausible theory of the unitary executive.
So I've double checked, but I want to triple and quadruple check. This surprised me that the delays went up and significantly went up for agencies. I want to put some hesitations on it. So the numbers are really small, Ron, in the White House agency and executive agency category, but they're not so small for cabinet departments, which went from in the year before, a confirmation delay for successful nominations was 84 days and went up to 140 days in the year after, and also for independent regulatory commissions and boards, which went from about 100 to 125. So that's one. So it's very disturbing, maybe, or surprising for those categories. And I want to caution about the executive and White House agencies. But two, another hesitation I want to place is that the failure rates did go down. So it did help in terms of the percentage of nominations that were submitted to the Senate eventually getting confirmed. That did go down for cabinet departments. So in the year before, Obama, part of what was so frustrating, I think, to the Obama administration was in part some of these judicial nominations that weren't getting through, and the Senate Democrats, but also executive agency nominations that weren't getting through. So about half of cabinet department nominations in the year before were not getting through, and that number got cut down, right, to 30% of failure. So, that did improve. So you have to think about both.
Let me take, I think we have time for maybe two, but possibly only one question. Professor Schrader, you've had your hand up.
Thanks, John. Just a point of information on the filibuster change. The initial nuclear option didn't change the 30-hour rule.
Yeah, no, that's...
Which means that every nomination that comes up that the opposition wants to fight, even though you can, as your slide said, cut off debate, the opposition has the ability to tie up the Senate floor for 30 hours.
Yeah, no.
So it could be that after the option was triggered, the bomb was triggered, that the opposition decided they were not going to consent to any executive branch nominees, which is the way that most of them get through eventually, by unanimous consent. That would leave the majority leader with the choice of going one by one by one on executive nominees and taking potentially 30 hours of floor time for each one. I think that's probably the explanatory for why your number has gone up in the short term.
That's in the paper. That's right. That we changed from, there's different ways to get things confirmed. You can confirm by unanimous consent. You can confirm by a voice vote. You can confirm by a recorded vote. It's interesting to sort of see that those changes, even separate from the filibuster reform over time since 1981. But yeah, but
I thought that would be missed. I just wanted to make that comment. I started to raise my hand because I had an entirely different question that I wanted to ask, which was, I'm entirely in agreement with Bill with respect to my priors on this question, having served in the executive branch twice myself, but also having been chief counsel of the Senate Judiciary Committee and having no explanation other than obstruction for why things are so slow getting through the Judiciary Committee. Having said that, I do think it's important that the appointments process be understood in a larger theory of the way our very complicated system of checks and balances works. So I take the point made earlier that it's going to be very difficult to get any kind of consensus on the extent to which there's a problem unless the theory also takes into account the very legitimate concerns of people with whom I disagree politically, that they're losing their ability to control the executive branch. And as long as they have this lever and there's not an obstruction, an obstacle to it legally for them using it, as a practical matter, it's going to be a matter of political will to work changes in the Senate to improve the process, which I don't see occurring anytime soon. But to advance the argument that it might occur, my inclination would be to suggest the kind of inquiry that Nina's making is fundamentally important. Ultimately, you don't want to look at the length of delay or any kind of input or output numbers from the Senate, if that's what you care about. You want to look at the impact on governance. And that, I think, that's a very underanalyzed, because it's very difficult to do, question. In the judiciary, which I understand because I ran the Office of Legal Policy for 3 years in the Obama administration after having been held up for 11 months. So I've looked at this question a lot in the context of speeches I gave about how we were excoriating the Republicans in the Senate for the long periods of time that it took to get our judges through. And then when they finally got a vote, it was 99-0 or a voice vote, which showed it was just obstruction. I came to believe that at the end of the day, I didn't actually have a very strong case to make that these delays were damaging the judiciary in a very significant sense. And the reason is senior judges. So in that context, we had several districts that had 6 district judge slots, 5 vacancies. But they were functioning fine because the senior judges were continuing to shoulder 3/4 of a full load. So you couldn't tell by the numbers of vacancies whether you were having an impact on the institution. And so I think the executive branch is even harder to try to figure out than that. But my urging would be that that's the area of inquiry that I think is very much underdeveloped.
Let me just ask Professor Lewis. He's thought a little bit about the impacts on outcomes for administrative agencies. If you could just in 20 seconds kind of summarize what you think is going on. I think you've worked a lot on that.
In terms of, are vacancies bad?
Yeah, are vacancies bad for agencies?
Yeah, I mean, I think that the evidence, it's hard to measure government performance in general, but the evidence we have suggests that regardless of the quality of the people who are there, the regular turnover is bad for the long-term sort of management of the agencies themselves in terms of seeing reforms through, credibly committing to new initiatives. The careerists naturally get resistant when there's so much turnover or they're in a holding pattern. And because that's the case, the long-term health of the agency seems to be declining, at least in terms of things like what they say on surveys and different kinds of program evaluations.
Great. So unfortunately, we've run out of time. I want to thank the DLJ and the symposium organizers. I particularly want to thank all of our panelists. Thank you very much.
All right, we'd like to thank again all of our panelists in the appointment delays discussion. Thank you for all of your hard work this morning. At this point, we're going to be moving on to our next panel on appointment politics. So at this point,